Court ready?
All right. Appeal in the matter of Milton Keynes Hospital's NHS Foundation Trust and Commissioners for Majesty Tribunal.
If
Yes,
your
Mr.
Lordship
Southern.
pleases.
I can tell you that we've obviously read the skeleton arguments and we have read the two tribunal decisions.
I'm most grateful, my Lord. I appear on behalf of the appellant with Mr. Dennis Edwards, and my learned friend, Miss Valentina Sloan, Queen's Counsel, appears for the Crown. There's one housekeeping point. We've introduced 5 new pages to the authorities, to the statutes, 47A, B and C, and 50A and 50B. They may have been added to the court's files. My learned friend was warned.
47A, I've got section 15 of the Finance Act 1988. 47B looks like a bit of the VAT Act 1983. And what was the other page?
47C.
47C.
Also part
Yes,
of
that's
Schedule
part of
7.
And then
Schedule 7.
50A and 50B, which are the first 3 articles of the Principal VAT Directive, which
Right.
were omitted by inadvertence.
Yes, I've got all that.
Now, we propose to present our appeal under 5 headings, my Lord. Firstly, why the first-tier tribunal and the Upper Tribunal erred in law as to the meaning of any person in Value Added Tax Act 1994, Section 72, subsection 3. Secondly, why the Upper Tribunal also erred with its alternative argument that because the National Health Service Trust was registered for VAT for the purposes of its business activities, the appellant was registered as a taxable person for all purposes.
Yeah.
And then heading 3, why the structure of the legislation, both domestic and EU, supports the Trust's case that it is not a taxable person within Section 73, subsection 2.
I'm sorry, I didn't quite follow that. Where in section 73(2) is the phrase taxable person?
Section 73(2) is in person. That's the whole point. Section 73(2) uses the words any person. The commissioners say that means...
Yeah, but your heading was why the structure of the legislation supports the trust position that it is not a taxable person within 73(2). And I'm just asking where in 73(2) does the phrase taxable person appear? The phrase prescribed accounting period appears, but not the phrase taxable person.
Then I should have rephrased that, my lord.
It should surely delete the word taxable. Is not a person within 73(2).
I think that solves it. Yes, indeed, my lord. Thank you.
Right?
I suppose, or a person to which 73(2) is referring, which is the same.
Yeah.
Then heading 4, why the public sector refund schemes in Value Added Tax Act sections 33 and 41(3) were needed, because public bodies acting as such don't fall within the scope of the VAT scheme. And then fifthly, why the reasoning of the first tier tribunal and the upper tribunal led to an incorrect conclusion. Now, I will address the first, second, fourth and fifth headings, and Mr. Edwards will consider the third.
Right.
So the issue is, as your lordships just anticipated, the issue is whether any person in Value Added Tax Act section 73 subsection 2 refers only to taxable persons, as the appellant argues, or applies to persons generally, as the commissioners contend and the first tier tribunal and the upper tribunal so found. So the starting point of the case is that the appellant, when performing its statutory function of providing health care free at the point of delivery, is a public authority governed by public law. As such, in that capacity, it is outside the VAT system. And we set this out in paragraph 12 of our skeleton argument, which is in the core bundle at page 5. Now, VAT is a tax on activities carried on in a market. And in that market, supplies of goods or services are made by taxable persons for a price. In UK parlance, this is business activity, and the value-added tax legislation calls the price consideration. So consideration is the monetary equivalent of the goods or services supplied. If I have a haircut for £30, £30 is the monetary equivalent of the service supplied. Now, public authorities acting as such do not operate in a market. They don't sell goods and services. Their activities are outside the VAT system because they do not operate in a market. Their activities have a social value, not a monetary value. So if there's no consideration, there's no supply for VAT purposes. And a public authority acting as such is not a taxable person for VAT purposes. So the appellant's argument is that section 73 subsection 2 only applies to taxable persons, therefore it cannot apply to the appellant when it's acting as a public authority.
If you're right about that, is the consequence that the trust is entitled to keep the VAT, which is, on the HMRC's case, wrongly claimed?
That depends upon whether there is in the system, in the statutory system, a system for recovering what the commissioners regard as excessive refunds.
You say there isn't. You say there isn't. The commissioners point to section 73 as being the machinery for recovering wrongly refunded VAT. You say, well, that doesn't work. I don't think anybody's identified any other machinery. No. Therefore, is the consequence of your argument that the trust is entitled to retain public money which was wrongly paid to it?
There are two questions there. The first is whether the statutory scheme is comprehensive, which we would say it is, and the second is whether there is an independent common law remedy.
Is there?
We would say no, but
right.
my learned friend, this is a point my learned friend.
Yeah, no, all right. So the answer to my question is yes.
The answer to your question is
to
yes.
retain public money which
Yes.
it should never have had.
That is correct.
Yeah. Thank you.
And the facts are the simplest. The appellant is an NHS authority performing statutory duties. In particular, it supplies medical services free at the point of delivery. For VAT purposes, it's a government department. The appellant installed a new computer system. It paid VAT charged to it by the suppliers. In the financial years 2013 to 2014, to 2015 to 2016, as the project progressed, it recovered the VAT cost from the Treasury under the public sector refund scheme, pursuant to section 41(3) for the benefit of government departments. After examination of the claims, the commissioners concluded that the VAT cost had been over-recovered. The commissioners assessed the health authority in July 2017 under section 73 subsection 2 to recover the excess, and the VAT assessment is in the core bundle at tab 13, pages 122 to 124. And the amount recovery of which was sought was 121,506.63. As the assessment notes, the original view was that there was no appeal possible against denial of COS VAT, of the VAT recovered in this, sought to be recovered in this case, but they later changed their view on that aspect. Now, the health authority appealed to the first-tier tribunal, tax chamber, on two grounds, and those are in our skeleton at paragraph 3, which is the core bundle, page 2. And the first ground was that the assessment under section 73 subsection 2 was invalid because in respect of the statutory functions, the health authority was outside section 73(2). And secondly, the point your lordship raised, the amounts in question had in any case properly been recovered as a VAT.
We're only concerned with the first.
You're only concerned with the first, and as my learned friend points out in her skeleton argument, that's at paragraphs 3.1 and 9, which are on pages 20 and 23 of the core bundle. This is an issue which affects government departments generally, and it's been festering since about 2011.
Right.
Which is one reason why it's before this court. So, the two grounds of appeal now before the court are elaborated in paragraph 11 of our skeleton, which is at the core bundle, page 4, and I think I should probably read them in full.
Well, we have read them, Mr. Sullivan.
Then I won't read them in full. As I say, they're paragraph 11, page 4. So the issue is quite simply do you have to be a taxable person to come within section 73, subsection 2? And if you are a taxable person for one purpose, are you also a taxable person for other purposes? That's all the case comes down to. We probably ought to read section 73, subsection 2 in full. It's in the authorities at page 25. In any case where for any prescribed accounting period there has been paid or credited to any person as being repayment or refund of VAT or as being due to him as a VAT credit, an amount which ought not to have been so paid or credited, or which would not have been so paid or credited had the facts been known as they later turn out to be, the commissioners may assess that amount as being VAT due from him for that period and notify it to him accordingly. So the only question for this court is whether section 73(2) applies to a public body acting as such. The key issue, as I've already said many times, is whether public bodies acting as such, i.e. acting in that capacity, are taxable persons. If they are, section 73, subsection 2 applies to refunds of VAT costs under section 41, subsection 3, as the commissioners argue, and the tribunal so found.
Yeah.
If they are not taxable persons, section 73(2) cannot apply to recover refunds of the VAT costs recovered.
Well, that's your submission, but that depends on reading the word taxable into the first line of subsection 2.
It does indeed.
You say it has to be read in because of the reference to a prescribed accounting period.
That's our argument, yes.
Although, as I understand it, all these payments, if they were overpayments, were, all the refunds from the commissioners were paid in respect of prescribed accounting periods.
Yes. The question is whether the administration provisions, the provisions for the administration of the refunds can alter the substantive law if one has decided what the substantive law is. The question is whether that is the tail wagging the dog.
So you're saying that prescribed accounting period doesn't have any effect in relation to the meaning of any person in 73(2). It's just the mechanism, and that's all. And so we should read any person separately from any colour which might be given by prescribed accounting period. And we should read any person to read any taxable person. That's the
Yes,
bottom line.
that's in a nutshell, my lady.
Is that it? I'm afraid I had understood your argument differently. I had understood your argument to be that payments reclaimed under 73(2) had to have been payments made in respect of a prescribed accounting period. Only taxable persons as such, you say, you submit, have prescribed accounting periods. Therefore, payments under section 41 are not payments in respect of prescribed accounting periods and are not recoverable.
It comes down to the same issue, though obviously, as the court anticipates, it can be articulated in a number of ways. We say there are two separate issues here. What is the scope of section 73(2)? Does it only apply in relation to taxable persons who will be persons making taxable supplies? And we say yes, that must be the case because of the reference to prescribed accounting periods. Only taxable persons can have prescribed accounting periods, and that's fundamental to the VAT system. So, first you establish the proper scope of section 73(2). And we need to remember that 73 is concerned with collecting arrears or shortfalls of VAT. There's a collection section. That's why there's the assessment power in section 73(2). But quite apart from that question, there is the question, well, how do we go about the mechanics of refunding to public or to government departments and bodies treated as government departments? How do we go about the business of actually transferring the money back to them? The money which they have paid as output tax charged to them by their private sector suppliers. That's an entirely separate administrative matter. And for reasons of administrative simplicity and convenience, given that all government departments will be registered for VAT because they will have a small but significant amount of business supplies, given that they're already registered for VAT, then the obvious and simple way of administering the tax or administering the refunds of the tax is to use the existing prescribed accounting periods which they're using. So we would say that the way the refunds are made has no relevance to the interpretation of section 73 subsection 2. It's simply a convenient and practical administrative mechanism. So I hope that's consistent with both what I've said to your ladyship and to yourself, sir.
Can I ask you a different question, Mr. Southern? I see from the print of section 73 in our bundle that it has been superseded. It was in force up to the 30th of December 2020. Is there a current equivalent, or does it just not matter for the purposes of this appeal?
The changes don't matter.
So
the changes are all in connection with Brexit, and they're contained in Schedule 1 to the International Trade Act, I think it's called.
Right.
Does our
decision on the legislation that is in our bundle will it continue to apply post-Brexit?
It will continue to apply post-Brexit.
Thank you.
Yes, my lord.
Because this is, of course, a provision that has nothing to do with, or 41 is a provision that has nothing to do with Euro law.
Absolutely. That is one of our points, my lord, and I don't think that's disputed.
No.
Well, that takes us then conveniently. No, as I say, really, however the question's articulated, it always comes back to the same issue.
Yeah.
So, excuse me. That takes us to heading 1, why the first-tier tribunal and upper tribunal erred in law as to the meaning of any person in section 72, subsection 3. Now, the first-tier tribunal and upper tribunal found that 1, persons in section 73(2) means persons in general. Secondly, VAT in section 73(2) simply means VAT. And thirdly, in any case, the appellant is registered for VAT as a taxable person, so even if we're correct on the person means taxable person argument, that gets the appellant nowhere. The appellant is in any case a taxable person by virtue of being so registered. So it's obvious, according to the first tier tribunal and the upper tribunal, that it comes within section 73, subsection 2, if the commissioners determine that the government department has over-recovered VAT. This conclusion, the tribunals say, accords with both the literal wording of the language in section 72(3) and with the scheme and purpose of the Value Added Tax Act. In trying to argue otherwise, the appellant is putting forward an impossible argument, factually and legally. As the upper tribunal said in refusing permission to appeal, any prospect of success would be fanciful at best.
Yeah, well, we've read both those decisions.
And my learned friend adopts that in paragraph 4 of her skeleton argument, which is on page 20 of the core bundle. Now, per contra, the appellant argues that its own argument both accords with and is required with by both the ordinary and natural wording of the language in section 72, subsection 3, and with the scheme and purposes of the Value Added Tax Act. And it's on this point that permission to appeal to this court was granted.
Yes.
That's at page 77 of the core bundle. So, the decision of the upper tribunal. The commissioner's case, as upheld by the first tier tribunal and upper tribunal, is that Value Added Tax Act section 73, subsection 2, applies to such a body acting in its public law capacity.
Mr. Southern, we know what they decided. You were going to tell us why they were wrong.
Well, it's really at paragraphs 23, 24 and 25 of the upper tribunal's decision. So if I could refer the court to those paragraphs. And I think I should probably read them out.
We have read
page
them.
84? Right.
We have read them.
Then I won't read them again, my lord. Paragraph 24 contains 3 propositions. The distinction between a person and a taxable person is fundamental to the VAT legislation. Secondly, the Value Added Tax Act distinguishes between a person and a taxable person, and section 3, subsection 2, is expressed to apply to any person. Where a particular provision is applicable only to a narrower category of persons, it says so. Now, we would respectfully agree with all 3 propositions of the tribunal, which are, I would suggest, self-evident. But that statement of principles is complete.
Is
Incomplete.
incomplete.
There's a 4th proposition, and its omission causes the structure erected by the first tier tribunal and upper tribunal to collapse. It is built not on rock, but on sand. And the 4th proposition is that where the Value Added Tax Act uses the term person, the context makes it clear whether it means taxable person or person in a wider sense. And this is precisely what section 73, subsection 2 does, as does the whole of that section. And in our submission, the only true and reasonable conclusion which the upper tribunal could draw was that that person in section 73(2) meant taxable person. Now, the Upper Tribunal refers in paragraph 24 to section 3.1 of the Value Added Tax Act, and section 3.1 is in the authorities at page 6. One example of person meaning taxable person can be found in section 3 itself. So section 3, subsection 3 says, persons registered under any of those schedules shall be registered in a single register kept by the commissioners for the purpose of this Act. So here person can only mean taxable person, because only taxable persons are registered for the purposes of the Act in accordance with section 3.1 and 3.2. To say taxable persons registered under any of those schedules are taxable persons would be OTOs. That's a self-administered tax. The whole scheme is essentially run by the taxpayer himself, and a taxable person must account for VAT by reference to prescribed accounting periods. That's in the Value Added Tax Act, section 25.1, which is in the authorities at tab 11, at page 11. So if we simply look, if the court looks at section 25, just saying the authorities at tab 11.
Tab 6.
Yeah, tab 6, I do beg your pardon, page 11, yes. Payments by reference to accounting periods and credit for input tax against output tax. 25.1, a taxable person shall, in respect of supplies made by him and in respect of the acquisition by him from other member states of any goods, account for and pay VAT by reference to such periods in this Act referred to as prescribed accounting periods at such time and in such manner as may be determined by or under regulations, and regulations may make different provision for different circumstances. So note that there's no obligation to account for input tax. That's for two reasons. Firstly, the supplier will account for that tax as his output tax, so the input tax claim can be checked against the supplier's VAT account, providing a check on the accuracy of both. And secondly, there's no obligation to recover input tax because it's in the trader's interest to do so. But in order to recover his input tax, he has to obtain a VAT invoice from his supplier, which is the beauty of the VAT system, that it's self-policing. Now, if we now go to section 73.2, and your ladyship has already made the point, if we go to section 73.2, the meaning of any person in section 73, subsection 2, is limited by the preceding words, any prescribed accounting period. So the question then is, who has a prescribed accounting period? And the answer is only a person, the only person required to have a prescribed accounting period is a taxable person making a taxable supplies. Only a taxable person can have a prescribed accounting period. Any person in this context means and can only mean any taxable person.
And that really is the long and short of the point, isn't it?
That is the long and short of the point, indeed, my lord.
Seems to me to be difficult to elaborate it very much. But anyway, you have a go.
I would not. I would certainly share that conclusion with the court. As I mean, I've already said, however many times we go round in circles,
You've just come back
to the same point.
Yes.
It is, though, we would say, because this is very much a context-based argument, we would say not only is that reinforced, not merely reinforced, but required by the context in which the term is used and its role in the VAT system, that it produces a sensible system in accordance with what Parliament has ordained.
Yeah.
My learned friend actually, in her skeleton at paragraph 6, which is in the core bundle at 021, says that prescribed accounting period is used to start the limitation period running, but that, of course, it begs the legislative question of whether we're a taxable person or not within section 73, subsection 2. But it isn't only the use of the word, the presence of the words prescribed accounting period. For good measure, section 73, subsection 2 refers to a refund or repayment or refund of VAT and of that credit. Now, VAT is defined as input tax and output tax. That's in section 96. That's in the authorities on pages 43 and 44. And then input tax and output tax are in turn defined in section 24 by reference to taxable persons. So if we go to section 24...
I'm sorry, just help me on this. Section 96, you say defines...
It defines VAT.
Yes, it does. It says value-added tax charged in accordance with this act. I thought you said it was defined as input tax or output tax. But...
Well, then we go back to section 24 for VAT charged in accordance with this act.
So section 24.
Section 24, which is page 8 of the authorities.
Yes.
Input tax and output tax, subject to the following provisions of this section. Input tax in relation to a taxable person means the following tax, that is to say, VAT on the supply to of any goods and services, etc. Subject to the following provisions of this section, output tax in relation to a taxable person means VAT on supplies which he makes, or on the acquisition by him from another member state of goods, including VAT, which is also to be accounted as input tax by virtue of subsection 1b above. So, VAT means VAT, as the first tier tribunal said, and VAT means input tax or output tax. That's what it's about.
So when I look at section 41, subsection 3, which says that if you make a claim in the right manner, the commissioners will refund you the amount of, quote, the VAT, unquote. What are they refunding?
What they're referring to there is the output tax which has been charged to you by your supplier as a public body.
Right.
So where VAT is chargeable on the supply of goods or services to a government department, that's the amount the recovery is made in respect of.
Why shouldn't it mean the same thing in section 73?
Because in section 73, in our submission, the reference is to taxable persons.
Well, I follow that. I mean, that I understood.
Well, the answer is, and we will come to this later, is that a person who is not a taxpayer, either because he's a public authority or because he's a consumer, which would include a person whose tax supplies are under, who's making sales of goods and services beyond the registration threshold, he pays output tax, but the amount that he has paid is simply a VAT cost. It isn't input tax, because input tax is a payment which can be recovered in the hands of a taxable person. That's why VAT invoices are such valuable items. And so the VAT which a person pays and cannot recover is not input tax. It's colloquially referred to as non-input tax, or Lord Justice Schliemann's term in the Cardiff case as non-business VAT. It's simply not input tax and not output tax.
Well, in the hands of the, as regards the supplier, it's output tax.
Precisely.
As regards the department, it's just a cost. But if it's a cost which falls within the scope of Section 41, the department or other public body can make a claim for it to be refunded.
Indeed, ma'am.
And if it is to be refunded, the claim is to refund the amount of the VAT so chargeable.
We say
So it's
that
VAT.
means the amount of output tax charged to the government department.
Yes,
Yes.
Yes.
but it's VAT.
Of course it is. If I go and buy a shirt and I pay a price to the shop that sells me the shirt, part of that price is going to be VAT. I have paid VAT, surely.
Yes, exactly.
It's not my input tax
Yeah.
because I'm the consumer, but I've paid the VAT.
Yes, you have indeed, my lord. It is a VAT cost. I think that is the best description of it. There are all these alternative descriptions of non-input tax and non-business VAT.
But your
We would
submission-
say, I do beg your pardon, my lord.
your submission appeared to be that it wasn't VAT at all, because it's neither input tax nor, so far as the department is concerned, output tax.
In relation to a taxable person, our submission would be VAT has the specific meaning of input tax and output
Yeah.
tax. And the value-added tax is addressed to taxable persons in the same way that the Income Tax Act is addressed to people with taxable income. But you obviously have to refer to circumstances where VAT is a more general cost, not in relation to taxable persons. And in those cases, yes, you refer in a looser sense to VAT. That's entirely sensible and correct, my lord, as in the example my lordship gives of going out to buy a shirt.
But it's still VAT.
Well, this is why the first tier tribunal said, well, this is all semantics, isn't it? And the answer is, it's VAT in a colloquial sense, but it's not VAT in the statutory sense of input tax and output tax. And the legislation, as is the nature of legislation, is concerned with making precise definitions and applications.
Well, I would have thought the draftsman of Section 41(3) might take exception to the proposition that he's using the word in a colloquial sense.
Well, I don't think he is there actually in 41.3 because he's specified it back. No, the words refer back to where VAT is chargeable on the supply of goods
Yes.
or services.
Yeah.
And that fits in with the way in which VAT is defined in section 96, which is just VAT means value-added tax charged in accordance with this Act, or where the context requires with the law of another member state. And so one cannot assume, surely, that the draftsman is using the term in a loose or colloquial sense.
That would be precisely our case, my ladyship, and one would never assume that a draftsman uses words without very careful thought. That's what his job is.
So in 41.3, we have the phrase, shall, on a claim, etc., refund to it, the government body, the amount of the VAT so chargeable. And in 73.2, we have the case of where there has been paid or credited to any person as being a repayment or refund of VAT. And why, the question is this, why does that not cover a refund of the amount of the VAT so chargeable under 41.3 if it was more than was due?
We would say because what section 73.2 is referring to is input tax and output tax, and the amount which the government department has paid to its supplier, in addition to the costs of the services, the amount that the government department has paid is indeed an output tax in the hands of the supplier, but is not output tax or input tax in the hands of the government department. It is simply what Lord Justice Sheeman called non-business VAT.
Yeah. All right, I think we've got that point.
In fact, I think the wording of 73.2 reinforces that. Repayment or refund you find elsewhere in the Act, both as a phrase and as repayment or refund separately. But what B is referring to is specifically defined in section 25, subsection 3. What that is looking at is the case of a repayment trader like Tesco's who recovers more in input tax than it pays in output tax because it makes so many zero-rated supplies. So credit within section 73, subsection 2b is actually defined in section 25, subsection 3, which is at page 11 of the authorities. And what that says there is that if either no output tax is due at the end of the period, or the amount of the credit exceeds that of the output tax, then, subject to subsections 4 and 5 below, the amount of the credit, or, as the case may be, the amount of the excess shall be paid to the taxable person by the commissioners, and an amount which is due under this subsection is referred to in this Act as a VAT credit. So a VAT credit in section 73, subsection 2, is specifically defined as being input tax in the hands of an repayment trader, which is specifically recoverable under section 25, subsection 3, defining that credit for the purposes of the Act.
So that has no relevance to government departments.
It has no relevance to government departments, but it has relevance to whether any person in section 73(2) means taxable person, as we submit.
Well, that depends on how one reads 2A, among other things.
Of course, any person can include taxable persons. Of course it can. So section 73(2)(b) is perfectly well accommodated within the phrase any person, because it will include taxable persons who are entitled to the credit under section 25. But your argument is not that any person includes taxable persons, but that any person is limited to taxable persons. Well, you don't get any help in that argument from section 25, do you?
Yes, I think we do, because what section 25(3) is saying, that the VAT credit, which is repaid, but if it's an excessive VAT credit, the commissioners may recover the excess by an assessment under section 73 subsection 2, is confined to input tax recovered by repayment traders. So we're specifically in the taxable person scenario. Now, of course, as I've said, it's the parliamentary draftsman makes it clear by the context in which he uses his terms whether he means taxable person or whether he means person in a wider sense. And clearly in other situations, the legislation has a wider application than to taxable persons. And the obvious example is section 72, the preceding section, which is dealing with offences. And the authorities at page 22. And there, that says, 72(1), if any person is knowingly concerned in, or in the taking of steps with a view...
I think you're on page 20, actually. It doesn't
I do
doesn't
beg
make
your
much
pardon,
difference, because
Yes.
page 20 is the England and Wales provision.
Yes.
Yeah.
If any person is knowingly concerned in, or in the taking of steps with a view to fraudulent evasion of VAT by him, by any other person, he shall be liable, etc. And obviously, person there means person in a wide sense,
Yes, of course.
because you don't have to be a taxable person to commit tax fraud.
Of course.
It's not a condition.
Yeah. Can I just go back for a moment for section 73 and its interrelation with 25? You've shown us section 25, and so a taxable person tops up his input tax, sets it off against his output tax, and if the input tax exceeds the output tax, he's entitled to a VAT credit. And as you have rightly said, taxable persons are required to make VAT returns by reference to prescribed accounting periods. So at the end of every prescribed accounting period, HMRC will get a return which either shows an amount due as VAT or a credit. That is the mechanism by which the taxable person accounts for VAT. When does a taxable person get a repayment or refund of VAT as opposed to a VAT credit?
He may get a repayment or refund of VAT in two circumstances. And in her judgment in Cardiff, Lady Justice Arden sought to give a more precise meaning to repayment and refund. What she suggested there was that repayment relates to situations where there is a liability, but it has been overcalculated, so a repayment is due, and refund is a situation where there was no liability at all. So, if there's a simple accounting error and you over-account for your VAT, or if you're accounting for VAT on an accounts basis and you're not paid by some of your customers, so you have bad debt relief, in those circumstances you will have had a liability, but it will have been an excessive liability, so the amount can be recovered in one of the number of ways which the Act provides for.
Thank you.
If it's a refund, I think probably maintaining the distinction suggested by Lady Justice Arden is difficult in all the circumstances of the Act. But if there has been no liability at all, this would be a situation where you treated a supply as being standard rated when it turned out to be zero rated, so you in fact overpaid your VAT. And these happen every day.
And does she refer to the statutory provisions which, under which either a repayment or a refund can arise?
The actual mechanisms for doing it, sir.
Well, my lord asked you in what circumstances there could be a repayment or a refund as opposed to a tax credit to a taxable person under the Act. And I had supposed you might refer to some specific provisions of the Act. But if you don't wish to...
No, by all means. Errors, if it's an error of up to £10,000, it can be recovered simply by an entry in another VAT return without making a note of it. If it's between £10,000 and £50,000, you fill in a form, or normally you fill in a form 652 to explain why there's been an overpayment or an underpayment, and then you can recover the amount through your VAT form under Regulation 38. If it's for a larger amount, then you have to make what used to be called a voluntary disclosure, but is now called a error correction return. So it's provided for in the regulations.
And what do those lead to if it turns out that you have overpaid?
You then get repayment from the commissioners bearing interest at the official rate from the date of the overpayment.
So that's a repayment as opposed to a VAT credit.
Well, VAT credit has this specific meaning in 25.3. That's for repayment traders. That's with the Tesco's of the world. I mean, you know, it's, you see, equally you get these situations where people have under-recovered their output, their input tax, but then there are separate provisions for those. Those are in Regulation 29 of the VAT regulations. And this great revolution in VAT began in the year 2000 in the decision of Mr. Justice Newberger, as he then was, in University of Sussex, where the commissioners had argued for, since 1973, that the same rules applied to the recovery of overpaid output tax as under-recovered input tax, but Mr. Justice Newberger in University of Sussex said no, there are separate rules for the recovery of overpaid output tax and separate rules for the recovery of under-recovered input tax. And that started a revolution in VAT. But that is a story for another day.
Yes. Well, where does our story go next?
Well, we've said that in some defined circumstances, take Section 72 offences, that clearly applies generally. Our submission is that the First Tier Tribunal and Upper Tribunal have not applied the ordinary and natural meaning of the words used. On the contrary, they've done the opposite. They've ignored the literal wording and have adopted an interpretation which is impossible to reconcile with the plain literal wording. Moreover, their interpretation makes no sense in the context of the VAT system and contradicts its basic premises. The clear and ambiguous meaning of the words used precisely dovetails with the context in which the words are set. So contrary to what the Upper Tribunal thought, contextualisation, far from distorting, brings out the correct interpretation of the statutory language.
Right. That seems to deal both with your headings 1 and 3. So I think
probably 3 requires a more thorough survey than
right.
I've been able to give, and Mr. Edwards will be able to bring out the inwardness of some of the legislation. Our case is really summed up in paragraphs 16 and 64 of our skeleton at it's in the core bundle on pages 5 and page 6 and page 16, paragraph 16 and 64. And as we say, the Upper Tribunal can't have it both ways.
Yeah.
It can't say that the issue has to be decided on a literal interpretation of section 73, subsection 2, but then fail to attribute any meaning to the words for any prescribed accounting period.
Yes.
So that was our heading 1.
Right.
Heading 2 was the Upper Tribunal's alternative argument. And we deal with this in our skeleton at paragraphs 18, 23 to 27, and 66 to 72. Those are on pages 6 to 8 and 17 to 18 of the core bundle.
Yes.
And what the Upper Tribunal said was that the appellant was indeed registered as a taxable person and so had a prescribed accounting period. Therefore, even on the appellant's reading of section 73(2), person means taxable person, that gets the appellant nowhere. This is a paragraphs 17, subparagraph 1, and paragraphs 28, subparagraph 4 of the Upper Tribunal's judgment. That's on pages core bundle 83 and 86. And so, having dismissed the prescribed accounting period argument, the Upper Tribunal continues. In any event, as we have explained, Milton Keynes Health Authority is registered for VAT and so, in fact, has a prescribed accounting period. And my learned friend's skeleton argument puts it this way at paragraph 18, which is in the core bundle at page 6. All bodies which make claims for section 41 refunds are registered for VAT and are taxable persons.
I think you told us that in your opening.
Indeed, my lord.
Yeah.
And
That's
say,
common ground.
I beg your pardon, my lord.
That's common ground.
It's common ground that all these bodies are registered for VAT.
It is indeed.
Because they all have, however small, some business activity which is above the threshold.
That is true, my lord. That's correct, yes.
Whether it's a shop in the hospital, car parking, or whatever it may
We say, though, that the argument that because they're registered as taxable persons makes them taxable persons within section 73 subsection 2 is putting the cart before the horse. Simply because a public body, including a government department, is a taxable person when it makes business supplies, it doesn't change its nature for VAT purposes when it's acting as a public body as such. So, first you have to decide whether the public authority acting in its public law capacity is a taxable person. If that is the case, then the fact that it's registered as a taxable person when acting in a business capacity is neither here nor there. The whole EU VAT scheme is that public bodies acting as such are not taxable persons. And not merely as a matter of reality are all government departments have to be registered for VAT because they make taxable supplies. In fact, they're also required to be registered even if they don't make any taxable supplies in order to recover their public sector VAT refunds. So in fact, if we look at the supplementary bundle...
I'm sorry, so that, just so that I understand, your point that you were making earlier was just because they are registered, because they have business activities, doesn't affect their status and the effect of their status as public bodies. So the fact that they're a taxable person for one purpose doesn't in any way infect their status when they're acting as a public body. That's what you were just saying. But then you say, in any event, for the purposes of section 41, they have to be registered anyway. And so that's what you said. So accordingly, your point must be that when they're registered for that purpose, it's different in quality from being registered for business purposes.
That's the essence of our case, my lady.
Yes.
How does that fit with section 3, which you showed us, which tells us that a person is a taxable person for the purposes of this Act, while he is, or is required to be, registered under this Act? Now, you've told us that even if they're not required to be registered for making supplies, the government departments and presumably other public sector bodies are registered if they want to take advantage of section 41. So they are, for that purpose at least, taxable persons because they are registered. So says section 3.
Yes, I think one's got to distinguish. Actually, if we look at the supplementary bundle, I think it's on page 123.
Which document is this?
Oh no, sorry. I think it's on page 23.
Of the supplementary?
Yes.
So I'll find the reference. I can't understand my own reference here.
Is this one of the guidance documents?
It's one of the guidance documents. I'll find the reference over the short break, because it says here supplementary bundle 123, but that's not right.
There's one at page 15,
I think.
question 1.22.
I think your lordship may have it.
Says GDs are required to register for VAT regardless of the
I'm
annual
most
value of
grateful.
their tax.
That's precisely the passage I was looking
Yeah.
for, yes. But we would say that isn't a legal arrangement, that's an administrative arrangement.
Right.
A perfectly sensible administrative arrangement, and it works very well in practice. Whether there are any example, I suppose there must be small public bodies which don't make any taxable supplies, so it may well be relevant in those cases.
Yes. Right.
So what the Upper Tribunal is doing is making or deeming the Milton Keynes NHS Trust be a taxable person for all purposes, so as to fall within the assessment provisions of section 73, subsection 2. But as regards its statutory functions, the NHS Trust is not a taxable person. All government departments, we've already dealt with this point, all government departments and NHS bodies will be registered for VAT, if only because they operate canteens.
Yes.
And yes, I seem to recall that it was a condition of one's civil service contract that you had access to a civil service canteen. And the business activities of NHS authorities are considered in detail in supplementary bundle at pages 57 to 87 and 139 to 140. But we don't need to go into those. The main activities are going to be car parking and catering. For the purpose of these activities, your NHS Trust is a taxable person, and respect of these activities is accountable for VAT in exactly the same way as any other commercial supplier. If it underaccounts for output tax or overclaims input tax, it's assessable under section 73, subsection 2, in the normal way, as one would expect. But to argue from that it is also a taxable person when acting in its public law capacity is contrary to the scheme of the Principal VAT Directive. It has the effect of bringing public bodies acting as such into the scope of the VAT system.
But does it really do that except in respect of the particular provisions we're looking at?
But we say that would be to regard that as altering the substantive legal rules would be getting the administrative dog tail.
Well, I see your point, but it's an administrative dog which provides for refunds of something which is not input tax but is a VAT cost to the government department, and which provides a sanction if there has been an overpayment. What's wrong with that?
The question is,
especially when you tell us, Mr. Southern, that there is no other such remedy and no remedy at common law.
well, there are two answers to that. The first is that the primary question is always going to be, when acting in its public law capacity, is the health authority a taxable person? And we say the only answer to that under the directive can be no. And then the second point is, what has Parliament ordained? If this is what Parliament has ordained, this is what Parliament has ruled.
There's nothing in the directive, is there, which requires a refund scheme of this nature to be established?
Absolutely not. We'll deal with that under heading 4, but as we'll see, there is, obviously there's been,
It's not
Having this hidden VAT cost is
it's not
anathema.
required, but it is permitted.
You have it in a nutshell, my lord, yes. That's explained. I mean, there are two obvious reasons. One is that bodies which are financed out of taxes shouldn't be themselves be paying taxes. That's pointless recycling of tax revenues. Secondly, if a public authority can more efficiently and effectively buy in services from outside rather than providing its own internal services, then it's in the public interest that it should do so, and there shouldn't be a VAT cost in so doing. And then there's a third underlying reason, which is that hidden VAT is an anathema to the VAT system. And the problem of having public sector bodies bearing VAT which they don't recover, or VAT cost which they can't recover, is in, as it were, in tax design systems undesirable.
Yes.
So we're simply saying that because the body in question makes the necessary minimum of supplies for consideration so as to be registerable for VAT, so that it's a taxable person for that purpose and has a prescribed accounting period, it isn't a taxable person for all purposes and have a prescribed accounting period for all purposes. And this is the point which Sir Timothy raised earlier. The amounts which public authorities can recover under special refund schemes are not VAT in the sense of section 73, subsection 2. They're not input tax because only taxable persons have input tax. And when acting as a public authority, an NHS trust is not a taxable person. They're simply, as I've said, I think it's a convenient term, a VAT cost.
Yeah. No, we've got that point. I think
And
we've made it very well.
We claim support for that position from the decision of this court, both in the Northumbria healthcare case and in the Cardiff County Council case. So if I might refer the court briefly to those two cases and the passages we rely on. Now, Northumbria Healthcare is in the authorities at tab 27, at page 246, and we refer to it in paragraphs 57 and 58 of our skeleton argument, which is in the core bundle at pages 14 and pages 50. Now, the principle we would draw from both these cases is that a public authority which is a taxable person for certain persons is not and cannot be a taxable person for all purposes. Now, the starting point is not, as the Upper Tribunal stated at paragraph 20, value added tax section 41, subsection 3, but as the Court of Appeal stated in Northumbria, Articles 9 and 13 of the Principal VAT Directive and Value Added Tax Act, section 24, because these put a public body performing statutory functions, non-business functions, outside the scheme of VAT. So the Court of Appeal said at paragraphs 14 and 15, and that's on page 250 of the authorities, the court said the trust falls within this description, Principal VAT Directive Article 13.1, at least when it is carrying out its core purpose of providing healthcare within the NHS. It is not therefore a taxable person while carrying out these activities. Because the trust is not a taxable person in relation to its core activities, it does not have the right to deduct input tax paid on what it acquires under the usual system of offsetting input and output tax. That is why it had recourse to section 41 subsection 3 of the Value Added Tax Act. Now, necessarily implicit in that is that what it recovered under section 41.3 was not input tax. Having concluded that it was not a business supply, the leasing of cars to its employees, the VAT cost paid by the health authority was recoverable to the extent allowed under section 41.3. And what has led the tribunals below into error is that for reasons of administrative efficiency and convenience, the special VAT cost recovery procedures have been built into the ordinary VAT accounting arrangements. From the 1st of April 2010, the commissioners have integrated the operation of the VAT refund scheme for public authorities into the ordinary VAT accounting system. This is explained at paragraphs 23 to 27 of our skeleton argument. That's on core bundle pages 7 to 8, and by the Upper Tribunal at paragraph 9. If we look actually at the supplementary bundle at page 137, as we explain in our skeleton argument, and as the Upper Tribunal have explained, the government department, or in this case National Health Service Authority, fills in its ordinary VAT 100 return on making a monthly or quarterly VAT return, but then has an additional form VAT 21 attached to it, and the VAT 21 shows the amount of section 41 subsection 3 VAT claimed for the period. And then the two are added together to go into box 4, tax recoverable, so that it says on the page 137, explains what goes into the VAT 21, and says that box 4 of the VAT return must show the total input tax for the period plus the total VAT to be refunded under the Contract Out regulations. The figures should be equal to the total figure shown on the form VAT 21. So the guidance clearly distinguishes between input tax recoverable under box 4 and VAT costs recoverable under section 41.3, which are not input tax. The two figures are separately recorded and only aggregated to determine the amount payable to or recoverable from the commissioners. But none of this makes the public authority a taxable person when it's performing its statutory functions. As is explained in the guidance notes and our skeleton argument, the box 4 figure is always going to be an amalgamation of VAT claims under section 26, input tax recovery claims, and section 41(3) claims. And local authorities making their section 33 claims follow exactly the same procedure, except that there's no separate VAT 21 form used. So they recover on a pound-for-pound basis through the normal VAT return procedure, and otherwise they're subject to all the normal rules governing input tax and the right of recovery. If we look at the Cardiff County Council case, which is in the authorities at tab 23, this was a case where Cardiff County Council overpaid output tax, and at the time in question there was a 3-year time limit for the recovery of overpayments of output tax, but there was no time limit for under-recoveries of, in this case, section 33 rather than section 41(3) claims. So what the council argued was that overpayments of output tax were ipso facto under-recoveries of section 33 tax, and though the time limit of 3 years applied to the recoveries of the overpaid output tax, there was no time limit for the recovery of the balance of that overpayment as under-recovered section 33 tax. And what the case explains is that VAT recovered by public authorities under refund schemes is legally and conceptually different from input tax and not to be confused with it. And Lord Justice Sheeman uses the terms input tax and non-business VAT. And he also explains the method by which public authorities recover non-business VAT. So accordingly, VAT costs are divided into 3 categories. There's taxable input tax, which is input tax attributable to taxable supplies. There's exempt input tax, which is input tax attributable to exempt supplies, and non-input tax, or what Lord Justice Sheeman calls non-business VAT, which is input tax which is not attributable to supplies.
Not input tax, surely. You said it was input tax, but surely the point is it's not input tax. It would be input tax.
Well, precisely. I'm not expressing it as clearly as I should be. That's exactly right, my lord. I suppose what I should say is non-input tax, i.e. output tax. No. No, that doesn't work either.
The suppliers out.
I think I'm going to stick with Lord Justice Sheeman, non-business VAT. Oh, it's a VAT. No, that's the right thing to say. It's a VAT cost which is not attributable to supplies. I think that's the right way of saying it.
That's the VAT I pay when I buy my shirt.
Yeah.
That is exactly the. Yes, your lordship hits the nail on the head. It's rather like Monsieur Bourgeois speaking prose for years without realising it.
Yeah.
Well, I've outlined the facts briefly. The council overpaid output tax for the years 1991 to 92, to 2000 to 2001, claimed a repayment, but claims before the 1st of April 1997 were out of time, 3-year limitation period. Council
you want
claimed,
paragraphs 12 to 14 mainly, don't you?
yes. I mean, if we look at those paragraphs, in paragraph 12, the court says, because the supply is not for the purposes of any business carried on by the authority, it does not fall within the definitions of input tax contained in section 24. And then in paragraph 13, the court says that the result of authorities being subject to both the ordinary taxpayer regime and the special local authorities regime is that the VAT is that the VAT paid by local authorities to their suppliers falls into two notionally separate categories depending upon whether the supply was for business purposes or not. The former is properly described as input tax and can be dealt with under the ordinary taxpayer regime, and the latter, Lord Justice Sheeman says I shall describe as non-business VAT. So then at paragraph 14, he continues, the commissioners have therefore prescribed for local authorities in the position of the appellant a regime which spares them the trouble of separating out input tax from non-business VAT.
You needn't read it out.
I don't
Mr.
need
Southern.
to.
You just
No.
tell us what you want us to read and we'll read it.
Well, that's just those paragraphs.
Right. Do you want paragraph 38?
I've forgotten what paragraph 38 says.
It says it's got nothing to do with rights under community law.
That, yeah, precisely. Thank you, yes. I'm grateful, my lord. That brings us to the end of heading 2.
Yeah.
So that takes us to heading 3 on the structure of the legislation, which my learned friend Mr. Edwards was going to deal with.
Right.
My lords, my lady, just before I begin, if I could address briefly the question which my Lord Justice Lewison asked at the beginning about the alternative remedy which the commissioners might or might not have to recover the money if they can't do so under the VAT Act. I will acknowledge at the beginning that it is it's an unhappy result if that is the case. But my first submission on that point would be that it is not strictly a matter for this court. The legislation is complicated and the case law is also rather complicated. As my learned friend has indicated, we have the Total case where a divided House of Lords took the view that, the majority took the view that the legislation was not exclusive, in that it certainly allowed an alternative remedy to recover funds which had been lost as a result of a fraudulent conspiracy. But equally, as my learned friend also says, there's also the CPAD case in the complicated social security appeal arrangements, where the Supreme Court took the view that in that case the legislation was conclusive.
Well, you say it's not a matter for this court, but we are trying to work out the intention of Parliament in enacting Section 73 in the terms in which it did. And if it is your position, as Mr. Southern said it was, that not only can HMRC not use Section 73, but that there is no other remedy, with the consequence that, as he quite frankly accepted, what this means is that your client is entitled to retain public money which it should never have had. That's what I wrote down as answer to my question. The potential for that consequence is surely of relevance in trying to understand Parliament's intention, because it is an unlikely intention to attribute to Parliament that a public body should be entitled to retain public money which it should never have had.
I agree, my lord. But it is a policy argument in favour of a construction of the legislation which we say should be interpreted in light of its ordinary and natural meaning.
Yeah, no, I understand that.
I would also add, my lord, my lady, from personal experience, when the boot was on the other foot, that in a case I was involved in some years ago, which went to the Supreme Court in the social security context, called Payne and Cooper, and in that case again it was complex social security legislation, and the question was whether or not an overpayment of social security benefit was effectively cancelled out by a debt relief order. Now, it is clear from the judgments both in this court and in the Supreme Court that the natural and ordinary meaning of the legislation, which led to an unjust enrichment of the beneficiary of the social security payment, was a bitter pill to swallow. But if that was the ordinary and natural meaning of the legislation, then it was the one that had to fall.
Yeah.
And I can certainly, as I say, the boot was on the other foot in that case, and the restitutionary issues were there, but it could not disturb the ordinary and natural meaning of the legislation, however unhappy the result was.
Yeah, all right.
And I can cite that case further, provide copies to the Lordship, my lady, if you wish, but as I say, there was a clear concern that there was a very unhappy result, but it didn't disturb the ordinary and natural meaning of the legislation.
Right.
Now, as to that, my learned friend, Mr. Southern, has taken the court to Articles 9 and 13 of the Principal VAT Directive. And what I propose to do is essentially two things, and I will do it very briefly, because I can see the court has the points. That there is an EU context, although community law is not directly EU law is not directly relevant. There is, of course, an EU context in the Principal VAT Directive which we can't ignore, and it's EU law which has to be the starting point of what a taxable person is. And EU law approaches the meaning of a taxable person in essence by reference to his or her activities, so that we come to understand whether or not a person is a taxable person by reference to their activities. So when we look, for example, at Article 2 of the Principal VAT Directive, which was added to the court's bundle, I think, as 50A.
Yeah.
Sorry, which page?
50A.
50A, thank
tab
you.
19.
It's interesting, my lord, here we see that the Principal VAT Directive very much begins with activities. It starts with activities. In Article 2, it tells us that the following transactions shall be subject to VAT: the supply of goods and services for consideration by a taxable person acting as such. And the as such, of course, refers back to the supply of goods for consideration for the activities. The court has already been taken to Article 9 of the VAT Directive.
Yeah.
Yes, which is actually at page 51. Again, taxable person shall be any person who carries out in any place any economic activity, or business activity as it's translated into domestic law, and then we come to Article 13, which is undoubtedly a complicated provision and carves out almost all, but not quite all, the activities of public authorities.
I don't seem to have Article 13.
It's at tab
From the
20.
VAT scheme. And that,
20, right,
Yeah.
yes, 13.
Page 52.
page 52, is Article 13. Now, the problem which Article 13 seeks to grapple with is that public authorities do regularly make charges to the public for benefits and permissions which they grant. So, for example, they make charges for parking and for catering services, they run shops and hospitals, issue passports, and so on. And the question is whether these charges are consideration for VAT purposes, and the answer is in some cases yes. And so as a result, we might say that we have three situations in light of Articles 2, 9, and 13 of the Principal VAT Directive. First, we might say there's public authorities whose activities are fully outside the VAT system. Then we might say that we have private entities or undertakings who are fully within the VAT system. So that would be a taxable person acting as such. And then, of course, we have public authorities whose activities may be partly within and partly outside the VAT system, which in many ways would be the trust. Now, Article 13 seems to assign the activities of public authority within Category 3, either to Category 1 or 2. So for some purposes, they are public authorities acting as such, in which case they fall outside the tax scheme. Or they are, when making business supplies, they are treated as taxable persons. And that distinction is absolutely fundamental to the VAT scheme. Now, there is a further complication, which we don't have to detain ourselves long with here, which we might call an intermediate situation, which is dealt with in essence in the later paragraphs of Article 13. And it is a rather complicated one, but I'm sure familiar to the court, which is where a public authority acting as such still has to be subject to the charge to tax. For example, where not being chargeable would lead to a distortion of competition, for example. Now, strictly, our submission is that in that intermediate situation, it is not a taxable person. It's a public authority acting as such, which must come within the charge to tax. Now, we don't have the legislation before us, unfortunately, and again, I can provide it if I thought it was in the bundle, but it's not. But Section 41A of the VAT Act deals with at least some aspects of the second paragraph of Article 13. And without overcomplicating it, it does it in a number of ways. It does it to some extent by reference to the intermediate situation, a public body acting as such, coming within the charge to tax when there would be a distortion of competition. And then it also, as I recall, does it by providing in Schedule 1 to the legislation that certain activities of public authorities are subject to the charge to tax. And what is of interest is that Section 41A deems the public authority to be a taxable person for that purpose, for the Schedule 1 purposes. Now I say, my Lords, my Lady, that is of interest in that there has been a statutory deeming of the public authority acting as such as a matter of EU law, so that it comes within the charge to tax. It might be said colloquially to be it is deemed to be a taxable person, but it's only by virtue of that deeming. Now, the other thing that I wanted to do briefly was to try to look a little more closely at the structure of Section 73 itself. Section 73 has been the focus of much attention this morning, but I want to try to commend to the court that the whole of Section 73, not just Section 73.2, has to be looked at in order to understand, if I may, the story which Section 73 is telling. So that when we look at the heading, it's failure to make returns, etc. The primary focus of the section, the essential story, is to seek to cover lost VAT. And of course, what is of primary interest to us is this interesting, one might say unhelpful, switching between person and taxable person through the section. Now, our central submission in this, given what I've just said about the fundamental structure of the VAT scheme in EU law, the distinction between public bodies acting as such and taxable persons acting as such, my central submission on the construction of Section 73 is that the interpretation which the Commissioners wish has the effect of introducing a stranger into the terms of Section 73, specifically into Section 73.2, through an interpretation of the word person. And we say that, as has been stressed, the term person can only mean taxable person when the section as a whole is understood. So, for example, if we look at subsection 1, which we might say is the main theme of the section, where a person has failed to make any returns required under this Act, well, the only person who is required to make returns under this Act is a taxable person. So to use the word taxable person in subsection 1 would be superfluous. It would be circular to say where a taxable person failed to make any returns under this Act.
And it's only taxable persons who are required to keep documents and afford facilities.
Well, exactly.
That's a question.
The
answer is yes?
Yes. Because the documents are needed to support the invoices, to support the recovery and so forth.
So Section 73.1, in a sense, goes in two stages. You ask, well, is there a person? Yes. Was that person required to make a return under the Act? No, because he wasn't a taxable person. Therefore, he falls outside the scope of the section.
Yes.
But that's not reading a person as a taxable person. The control on the width of person in Section 73.1 is the further provision that that person must have failed to make a return required under the Act.
But the only person who would
exactly.
The only person who would be required to make a return under the Act would be a taxable person.
Precisely so. So the section read as a whole, that subsection read as a whole, is confined to taxable persons, but that is not because of the meaning of the two words "a person." It's because of the phrase "and it has failed to make any returns required under the Act."
But we can only understand the word person in the context of failed to make returns under this.
All right.
Yes. We say the same, I'm not going to go over it again, we say the same in relation to subsection 2, that the importance of the prescribed accounting period has to be coupled with the word person. Right? But in subsection 3, of course, an amount which has been paid to any person as being due to him as a VAT credit. Well, the only person who would be due a VAT credit would be a person who had made a return, because that would be for the deductibility of input tax. That could only be a taxable person. Yes, and then we have a person assessed in subsection 4. A person is assessed under subsection 1 and 2 in respect of the same prescribed accounting period. Well, it could only be a person with a prescribed accounting period in subsection 4. In subsection 5, where the person failing to make a return, and so on and so forth, well, again, it's all linked up with making of returns.
Ah. So returns may have to be made by someone in a representative capacity.
Yes.
In relation to another person.
Yes.
But the other person being a taxable person.
But are any of those characters, those we now have another cast of characters introduced into the scope of the section. We have trustees in bankruptcy, liquidators and so on. Are any of those persons apt to be combined with a public body?
No.
No, well, but with respect, you're looking at the meaning of the phrase "a person." Or
Well,
the
yes,
person.
but a public body would never have a liquidator.
No.
Or
Just hang on. Does 5 show? I hadn't thought of this. That there are persons who are required to make a return, who are not themselves taxable persons, but are instead personal representatives of a taxable person, a trustee in bankruptcy of a taxable person, etc.
Well, they're making the return on behalf of the person. They themselves may not be required, but Parliament has introduced another cast of characters to expand the term.
But it
person.
says was required to make the return as a PR or whatever in relation to another person. Now, the other person must be a taxable person, otherwise the question wouldn't arise.
The other person must be a taxable person, yes.
But here we have various categories of people, and I quite see that none of them will arise in relation to a NHS trust or local authority or whatever, public body. But these are persons who are not themselves taxable persons, but who are required to make a return.
By virtue of their legal relationship
Yes.
with the taxable
And so they
person.
would be within 73(1).
They could come within 73(1), but they have had to be specifically mentioned. The term person has been expanded by section 73(5). Whereas, were it not for that, it could have just come within the generality of person in 73(2). Another cast of characters. The point I'm trying to make, I think Your Lordship has it, that another cast of characters has been introduced into the section.
Yeah.
And then
And not one directly relevant to this case, fortunately.
I appreciate that, my lord, but context is important, of course.
Context is important, I agree.
And then, of course, when we look, interestingly, at subsection 7, subsection 6.
Which is the time limit.
Yeah.
That's a time limit. No, I don't want that, sorry. Subsection 7. We now have, interestingly, a taxable person has in the course or furtherance of a business. So, of course, lots of people could be doing things in the course of a business, persons, but the checking, which is required to make sure that the goods can be accounted for, is focused on taxable person. Because that would the only person that the commissioners would have the power to go and do the checks on, would of course be a taxable person. Right? And then in 7A and 7B, I appreciate not directly relevant to section 73(2), but we have more characters now coming onto the stage. We have the fiscal warehouse keeper in 7A, who may or may not be a taxable person. And we have the person removing his or her wine from the bond, and in somehow or other the VAT is lost. Mm-hmm. Also specifically mentioned. And then the section, like a bit like a classical symphony, in subsection 8, it then comes back to the main theme. It starts coming back to the main theme where it began in section 73(1. As a result of a person's failure to make a return for a prescribed accounting period. and so on. And again, person can only be a taxable person by reference to the returns for a prescribed accounting period.
Well, it could be one of these representatives.
Well, it could be, my lord, yes, and they are also introduced again, as I recall, at the end in subsection 10.
Yeah.
For the purposes of this section, notification to a personal representative. My point, which I perceive the court has, is that there's a cast of characters here who are featuring in the story that Section 73 is telling. And it's only by introducing a new and unmentioned character, a public person, a public body acting as such, who doesn't fall within the VAT scheme, into the context and terms and structure of Section 73.2, that the commissioners are able to fix it.
Yeah.
My learned friend, Mr. Southern, may return to this later, but while I'm on my feet, I would just say that the 2 points that I've already made. The points that my learned friend, Ms. Sloan, makes in her skeleton argument for the commissioners at paragraph 8 are arguments of policy, not of principle, about the construction of the legislation.
Yeah.
And my learned friend also makes the point towards the end of her skeleton argument. She makes a number of points, and I'll settle just for dealing with one at the moment, which is the issue of the right of appeal, which is section 84.10. Now again, what is interesting is that when we look at section 83 of the VAT legislation, now I'm not saying, my lords, my lady, that this is necessarily determinative of the section 73.2 interpretation. But what is interesting is that, as it does when it lists rights of appeal in a number of areas, in the VAT context, in the tax context, I mean, at one time in the immigration context, but what Parliament giveth it can taketh away. But when it lists rights of appeal, it does it in some detail. But it doesn't mention any right of appeal under section 33 or, for our purposes, section 41. Notwithstanding the highly prescriptive, almost itemised list of sections in respect of which a right of appeal to the tribunal exists. Now, my learned friend's answer to that is the belt and braces of section 84.10. Yes, that might work, but it's another fix.
So what we're contemplating here is that a public authority pays some VAT on some good or service supplied to it in the course of its public activities.
Yes.
It wants to claim the VAT refund under section 41. It makes the claim and HMRC refuse.
No right of appeal.
No right of appeal, yeah.
And no right of appeal under section 41 generally. Now, it may be that the prior decision can be looked at, as can often be the case with prior decisions.
But how does that help us on section 73, where there is a right of appeal?
Well, the right of appeal under section 73, that is correct. But there is no right of appeal, only a remedy of judicial review, in relation to all the matters under section 41. See?
Right.
But again, it's.
But how does that help us on section 73?
It doesn't help the court directly on section 73. The only point I'm seeking to make in response to my learned friend's point on section 84.10 is that the absence of a right of appeal in section 83, when there are so many other rights of appeal, it is interesting that it has been left out. And our submission is that well, at the end of the day, Parliament has not directed its mind to
Right.
the
So
interpretation.
your point is that Parliament hasn't really thought this through.
Hasn't thought it through completely.
All right.
Except when it lists all the characters in section 73. But
Right.
my learned friend needs to introduce a new character into section 73, which I say the terms of the section aren't apt to include for the reasons I
Yeah.
do. Unless I can help the court further, those are the submissions we would make on the structure of section 73.
Thank you very much, Mr. Edwards. Yes, Mr. Southern, we're now on to your heading
4 and 5. I think actually I can deal with these briefly, and I'll do my best to finish by the short interval.
Yes, please
That
do.
will fit in. Heading 4, we've dealt with UK public sector compensation schemes in our skeleton at paragraphs 12 and 13,
Yeah.
and 39 to 45, which are on pages 5 and 10 to 11
Yeah.
of the core bundle.
Well, these schemes are needed because for the reasons that you've given. Otherwise,
Indeed.
public
I-
authorities
there's only
local
2
government would end
points.
up paying tax.
Indeed.
Yeah, right.
There's only 2 points I'll make in relation to this. The tribunal did refer to the fact that, Sir Timothy mentioned it, that these public sector compensation schemes are not required under EU law, not forbidden under EU law, but permitted under it. And it has been the subject of this very long final report, which is in the supplementary bundle. And I just asked the trial court to look at pages 210 and 286. We quote from the second paragraph, 286, in our skeleton argument, and that emphasises that the idea of compensation is not new. Several member states are already operating refund schemes outside of the VAT system, and we'd attach importance to the words outside of the VAT system. There is, as I've said, a parallel system for local authorities, but there are a number of important differences with the local authority scheme, which of course goes back to 1973 under section 33 of what is now section 33 of the VAT Act. So the distinctions between section 41 subsection 3 scheme and the section 33 scheme are: section 33 confers a right to make a claim in section 33 itself, rather than through and to the extent of Treasury regulations. Secondly, under the local government scheme, this is unlike the local government scheme, which is a statutory scheme, the section 41(3) scheme is a discretionary scheme, which only applies to the extent that the Treasury so direct. That's section 41, subsection 3. The Treasury directions do not have legislative force. They don't go through any sort of parliamentary procedure. They're simply departmental directions internal to the public sector. And importantly, refund under section 41, subsection 3 is confined to services and only to eligible services. These are the contracted out services, hence the term COS VAT. So it's necessary to determine whether expenditure in question is on goods or services, and if services, whether it's an eligible service. And then fifthly, that the local authorities, I think by administrative practice, are not required to operate partial exemption in relation to their business supplies. So the general point we'd make in relation to our heading 5 is that COS VAT is not a refund of VAT as a tax entitlement in relation to economic activities, but an amount of VAT incurred in relation to non-business statutory activities as a public policy compensation scheme. It's part of a special legal regime. Then the final heading was why the reasoning of the first tier tribunal and upper tribunal led to an incorrect conclusion. The decision of the first tier tribunal is in the core bundle at tab 12, page 109. Now, at paragraph 12, the tribunal refers to Elida Gibbs and refers to the two exceptions to Article 23, which my learned friend, Mr. Edwards, has drawn the court's to attention to, where there's a risk by treating an activity as a non-taxable activity that it would give rise to a significant distortion of competition, or it's an Annex 1 activity. At 16, the tribunal refers to the status of section 41(3), and at 20, the tribunal says the dispute was just semantics. But in that, the tribunal only meant whether the refund could be described as part of the UK VAT system. And then at 21, the tribunal records, Mr. Southern was quite right, as HMRC accepted, to say that conceptually COS VAT was quite distinct from input VAT and formed no part of the EU VAT system. At 24, the tribunal notes that the commissioners accept that non-business VAT is not input VAT, underpayments recoverable under J are overpayments in the tribunal's, in the commissioner's view, under section 73(2). And at 24, the tribunal and the commissioners are recorded as agreeing.
Well, we don't need to go through the decision, Mr.
No, I
Southern.
don't.
We have read it.
You've read it.
You've told us what legal errors both the FTT and the Upper Tribunal made. They were wrong about the meaning of the phrase a person. They were wrong not to have given weight to the prescribed accounting periods. They were wrong to have treated your client as being a registered taxable person for the purposes of the scheme. So what else is this heading going to add to what you have already told us?
Nothing whatever,
Right,
my lord,
well,
except for one point,
All right.
if I may make just one point in
the
relation
added value point, if I can put it that way.
An added value, well, I hope it may be, my lord. The conclusion of the first tier tribunal is set out at, the tribunal says at 31, in other words, there was no suggestion that the amount of the assessment was amount of VAT due on supplies. It was simply deemed to be VAT due from the taxable person. And the conclusion set out at 35 to 36, the appellant's argument seemed fundamentally flawed to me in that they were bound to lose on the preliminary issue, whether they were right in their submissions or wrong. So the first tier tribunal's conclusion is based on a statutory deeming to be found in the words of section 73(2) as being VAT due from him. So what the first tier tribunal is saying is that something that was never VAT, was never repaid or refunded as VAT, is deemed to be VAT for which a public authority acting as such is liable, and that is VAT with meaning, within the meaning of the section.
Yeah. Well, it's only liable if it's been overpaid.
Well, we say, though, but to treat it as VAT in this way will be to drive a coach and horses through the fundamental distinction of the VAT system between a taxable person and a public authority acting as such, all by virtue of a deeming provision which marks the end of a subsection which begins with prescribed accounting period. Now, when in our submission, when section 73 subsection 2 uses the term VAT, it can only mean input VAT and output VAT.
Yeah, no, we've been over that. Yeah.
But there is indeed a statutory deeming here, but it's not as the first tier tribunal envisages it. Because the first tier tribunal has overlooked the words from him for that period. The deeming is to treat the amount assessable as VAT payable for the period in which the assessment it is made. It's nothing to do with extending the meaning of VAT or the scope of section 73 subsection 2 to non-business tax. Now, if we look at the assessment to tax, which, as I say, is in the core bundle, tab 13, page 122, that identifies 21 periods in which there has been an over-recovery and then makes a single assessment to recover it. And the deeming in section 73.2 relates to the assessment. It doesn't relate to the amount payable. And that's plain from the history of section 73.2. So at that point, if I could refer the court to these new pages we introduced, 47A, B and 47C. Now, 47A gives us the original form of this provision. This was Value Added Tax Act 1983, Schedule 7, paragraph 4(2). And the assessment is in respect of tax as being due from him in the prescribed accounting period in which the amount was repaid. So if there's an overpayment or under-declaration in 10 successive accounting periods, under the law in that Act 1983, 10 separate assessments had to be made. This was clearly inconvenient, and Finance Act 1988, Section 15, which is at 47C, introduced a new version of Schedule 7, paragraph 4, subpara 2 of the 1983 Act to enable a global assessment to be made. And it provides, in any case where there has been, for any prescribed accounting period, there has been paid or credited to any person as being repayment or refund of tax, or as being due to him under section 14(5) of this Act. And that's actually the tax credit provision we referred to earlier, now in section 25(3). An amount which ought not to have been so paid or credited, the commissioners may assess that amount as being tax due from him for that period and notify him accordingly. So, before the amendment in 1998, there had to be a separate assessments for the wrong payments or wrong input tax credits for each of the periods in which the overpayment had occurred. The deeming is to substitute a global assessment for the period in which the assessment is made as if the overpayment had occurred in that period as opposed to all the periods to which the assessment relates.
So,
And that section 73.2 is only concerned with global assessments, is confirmed by section 73.4. The deeming does not alter the meaning of VAT as used in section 73.2, as the first tier tribunal suggested. That's a matter of statutory definition. It does not remove the fundamental distinction between taxable persons having prescribed accounting periods and public authorities acting as such.
Mr.
Now-
Southern, I'm not sure I quite follow what you're saying. I think, were you saying the legislation before 1988 required a whole lot of separate assessments?
Yes.
But we haven't seen that legislation.
That I attempted to show the court in 47A and 47B.
Well, that's 1988.
No,
I think,
I
that
do
the-
beg.
I'm sorry to interrupt. I think
No, I do
that
beg
my
your pardon,
page
madam.
numbers have been incorrectly
Yes, they are.
lettered.
Ah,
And so
We start
So-
with the VAT Act 1983.
yeah. And that ought to be 47A.
and it's B in my copy,
Yeah.
but I
Yes,
think it
let's
should be
change
A.
those round. That's what puzzled me.
I do beg your pardon, my lord.
That was my fault.
So-
And so 1988 is C, I think.
1988 is 47C.
C, yes.
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 Oh, yes. So the starting point is the 1983 Act. And where does that show? And that's the provision that's amended in 1988.
That's correct, my lord.
So what we're looking, I see, we're looking at Schedule 7, paragraph 4, subparagraph 2. May assess that amount as being tax due from him in the prescribed accounting period in which the amount was repaid, or as the case may be paid, and notify him. I see. So in 1988, at 47C, we have what is virtually equivalent to 73.2. That it was presumably consolidated into 73.2. Was that right? Or is there some difference? At 47C, the new provision,
Yes.
in any case where, for any prescribed accounting period, there has been paid or credited to any person as being repayment or refund, or as due, an amount which ought not to have been so paid or credited, the Commissioners may assess that amount as being tax due from him for that period. Now that's the period in which the particular overpayment was made.
I think the crucial words are, as your lordship detects, an amount which ought not to have been so paid or credited.
Yeah.
The commissioners may assess that amount as being due from him for that period and modify and notify it to him accordingly. That period refers to the period of assessment.
Why? That period can only refer to a period previously referred to, which is any prescribed period in which the sum was paid or credited.
That I would respectfully agree that it isn't as clear as day,
I think.
but it's certainly how it's been understood and how it was intended, my lord.
But what seems to me to make the difference when we come to section 73 is subsection 4. Oh no, that's not an answer. That's separate assessments under 1 and 2. I don't, for myself, I mean, whether it matters is another is different. I don't, for myself, see how the words as being VAT due from him for that period can refer to any other period than the prescribed accounting period in which the relevant sum was paid or credited. But maybe we don't have to consider that, and maybe if we were to hold that, we would be putting several cats among pigeons and disturbing a current practice, and I wouldn't want to do that unless it was necessary.
I wouldn't. I wouldn't disagree with my lord. I mean, I think actually it would have to say those periods if it was going to refer back to when the underpayments were.
No, it's any individual repayment.
Yes.
So that the assessment that was made should amount to, in fact, to however many it is, 20 or so separate assessments for different periods with presumably different time limits.
Yes, because the limitation periods apply accounting period by accounting period. See section 73(6). So HMRC can't, at the end of 20 years, say, right, we're going back 20 years for picking up credits which we shouldn't have made. Do it accounting period by accounting period.
And the same wording is used in 73(2) at the end as one finds in 15(2).
But I don't think this is central to your appeal.
It's not central, no.
Or shall we move on then?
Yes. I mean, the only other thing, I don't know if it's whether Sir Timothy would account any weight to it. The commentator on the Finance Act 1988 for the Chartered Institute of Taxation simply wrote of the revision before 1988, before the 1988 amendment, this required assessment of wrong payments or wrong input tax credits for the period in which the payment was made.
Right, well, let's move on to the next.
Let's move on. In fact, I think we're just about finished, sir. I don't think I need to comment on the decision of the Upper Tribunal. You have why we think that was
Yes.
in error. There is just 2 points which I might draw the attention of the court to for completeness, having regard to my learned friend's skeleton argument. My learned friend, Mr. Edwards, has already referred briefly to the first one. My learned friend's skeleton argument at paragraph 32, core bundle, page 31, says section 83(1)(p) provides a right of appeal against a section 73(2) assessment, but there is no right of appeal against a refusal of a section 33 or section 41(3) refund. This might be thought to give rise to a jurisdictional gap, but the situation is addressed by section 84(10). And section 84(10) is in the authorities at tab 13, page 40. So what is the scope of this slightly mysterious provision in section 84(10)? That was considered by this court in the Metropolitan International Schools case. That's in the authorities at 26, page 235. In that case, there was a 2000 agreement between the commissioners and the taxpayer that the taxpayer was making mixed supplies, standard rated and zero rated. On the 27th of August 2009...
Sorry, before we go to this case, Mr. Southern, what is the proposition for which you wish to cite it?
My proposition is that it isn't available as a backdoor route to appeals where there is no specific appeal provided for under section 83. Right. So it doesn't fill the jurisdictional gap which my learned friend was concerned with.
Fine. Well, your position is that that there is no means of recovery that HMRC have. And I think your position is that if you are refused a refund under Section 41, there's nothing your clients can do about it except possibly apply for judicial review.
That is correct.
Right, all right, we've got that.
So,
If the point about Section 8410 becomes live, then we'll hear argument about it.
I'm grateful, my lord. And then there was another point my learned friend made in relation to Section 81, subsection 3, in the Commissioner's skeleton argument at paragraph 24, which is on page 28 of the core bundle. The netting off of the Section 21 refund due from HMRC against the VAT liabilities of the Government Department takes place by virtue of Section 81(3) of the Value Added Tax Act. There is accordingly no reason as a matter of the VAT system to exclude the use of VAT assessment powers. I think this is a reference to the previous practice of the Commissioners prior to April 2011, which is referred to in paragraph 3 of the Commissioner's skeleton argument. Now, the set-off provisions in Section 81, subsection 3 apply where an amount is due from the Commissioners to any person or under any provisions of the Act, and that person is liable to pay a sum of VAT, penalty, interest, or penalty. In a Section 73, subsection 2 situation, there's no amount due from the Commissioners. The boot is on the other foot to what is envisaged by Section 81, 3A. And as regards the B, a person has to be liable to pay a sum by way of VAT, and the effect of this was discussed in Cardiff at paragraphs 35, 45, and in detail by Lord Justice Scott Baker at 66 and 72, and we'd simply say that Section 81(3), the set-off envisaged by that, isn't applicable in these circumstances. It is no assistance to either the Health Trust or all the Commissioners in the situation with which the court is concerned. So, just summing up then, the conclusion, the appellant's interpretation of Section 73(2) is summed up in paragraph 62 of our skeleton argument.
Yeah.
And the appellant interprets this provision as follows. 1. A taxable person must account for VAT by reference to prescribed accounting periods. 2. The meaning of any person in Section 73(2) is limited by the preceding words, prescribed accounting period. Only a taxable person can have a prescribed accounting period, and any person means in this context any taxable person. Accordingly, 3, VAT means input tax or output tax, and refunds under Section 41(3) of the value added tax are not VAT and specifically not input tax. They're what Section 41(3) calls the amount of VAT so chargeable, i.e. the output tax charged by the supplier. And fourthly, when performing its statutory functions, a government department is outside the scope of VAT and so does not have a prescribed accounting period and is not a taxable person. So, by interpreting Section 73(2) to mean any person in general, the First Tier Tribunal and Upper Tribunal erred in law. That's our case, my lord. And there's
Thank you very
anything
much.
else I can help with.
No, thank you very much, Mr. Sutherland. Right, well, we will rise now for a few minutes just to see where we go, so don't go away.
Rise. Got rice?
Oh, thank you very much, Mr. Southern and Mr. Edwards, for your excellent argument. Miss Slane, we need not trouble you. For reasons which will be given later in writing, we will dismiss this appeal. Thank you very much.
Excuse me, I'll call my clerks to fetch my papers. Will you go to lock this call? No, that's fine. No problem. Yeah, okay, apologies. Yeah. There's no hurry, obviously. Someone from there can come down. Yeah, I'm still away. How are you? Oh, that's all right. Yeah. I'll just collect up all their belongings and